We broke the news just within the past 2 hours on our website, CBS5AZ.com. Casey Anthony breaking her silence and also declaring bankruptcy. With me now from the Frutkin law firm, Jonathan Frutkin. Appreciate your time, and we want to kind of put this into perspective because we say Casey Anthony has declared bankruptcy. That statement alone, you might think, who cares? It has sweeping, though, ramifications for the civil cases that are currently being litigated against her.
It does. I mean, there are 3 different lawsuits going on against her in Florida. All of those cases will be stayed, which means that they aren't in state court anymore. They'll go to bankruptcy court, where a single bankruptcy court judge will decide whether she's liable for those debts.
Now, I shared with you the 60-page document that was filed in the Middle District of Florida, the bankruptcy papers for Chapter 7. Anything stand out to you in those papers?
Well, a couple of things stood out. I mean, first of all, she doesn't show any income for the last 3 years. 0, none at all. And that's obviously a little bit surprising. It's also surprising that the largest creditor she reports is her own defense attorney, Jose Baez, $500,000, and that's obviously a striking figure.
Looking at all this just from a wide perspective, is this a smart move on her part?
Well, I mean, there's some advantages. You know, one of the advantages is obviously you're not in front of 3 different judges, potentially 3 different juries. And in that case, that's very beneficial. But also, in her schedule, she's listed 38 consultants and 8 different law firms and the IRS. She owes a lot of money, and frankly, it's kind of a wise move if she wants to move ahead, because remember, after the filing of a bankruptcy, assuming you get a discharge, all your future earnings are your own to keep, and so she might be thinking ahead.
I want to talk about where she's been and where she'll go from here, in that her location in Florida has been kept a secret, highly confidential. Now that she'll have to go through this process, we know that she'll have to take sworn testimony. Let's talk about that first of all. In the sworn testimony, can she just be asked anything, or is there a limitation as to what the judges and the trustees can ask her?
Well, the trustee has a very wide mandate. A trustee is appointed to basically investigate her assets, and that person's going to be able to ask a lot of questions and see a lot of things.
Would he be able to ask about the murder case and her daughter, or is he strictly limited to financial questions?
Well, if those things bear on her financial assets, then he will be able to ask them. You know, what's important in a case like this is knowing that the information about that case is going to allow her to maybe make some money from media rights and writing a book and all those things, and a trustee's going to be interested in that, and knowing what sort of things were already set up before this bankruptcy was filed.
I would imagine her attorneys would ask the federal judge to keep those meetings, at least the time and the location, confidential. Would they be successful in trying to do that?
I think probably what they'll be successful doing is kind of keeping control of the length of time and the number of people that could be in the room. But it's a public appearance, just like any court hearing. Although the judge won't be there, the trustee will be there, and the creditors are allowed to come too by law.
Gotcha. Jonathan Frutkin from the Frutkin Law Firm, certainly appreciate your time and perspective. Thanks so much. That story online right now at CBS5AZ.com. Expecting more reaction as we go throughout the day and throughout the weekend. Keep it here on CBS 5. We'll be right back.